And basically, the idea of an executive order is a mandate or a direction that the president is giving, or the governor, on how laws are the means and methods for enforcing law, or not enforcing, the means and methods you won't be using. How is the law to be enforced or not enforced? Now, what I want you to know about an executive order is that an executive order cannot change the law. It can't, because that would be legislating, right? It cannot modify the law or create new law, because that's legislating. So that would violate separation of powers. I'm making it sound real crystal clear, right? It's not that way in the real world. A lot of gray area between this is how you enforce the law or not enforce the law and legislating. And it's not always clear cut. I'll tell you that right now. There's a lot of overlap. It's gray area. But courts have the authority to review executive orders to make that decision. That's a check and a balance by the judicial branch. The ability to review whether an executive order goes beyond the scope of a proper order into the area of legislating. All right. Let's talk about court decisions. So now we're going to get into the area of the judicial branch. Now remember, we're talking about sources of law. So who makes the law? Well, we know legislative branch. We also know the executive branch makes law, right? Well, what about judges? Do judges make law? Is there a separation of powers problem there? Can judges make law legally? Well, no, that's the legislative. So why do I have that up here? Well, this gets us into this whole area of what we call judge-made law. Court decisions. Case law. Right here, case law. Precedents. You've heard those terms before. Is there precedent for that? What is the case law? What does the judge have to say, or the previous cases, all that kind of thing. So here's what I'm talking about, okay? When a judge makes a decision, that decision, depending on the level of the court, is written down and put into a book. And then we as lawyers and other judges can go read those decisions. And those decisions help guide us on how to apply the law to a particular circumstance. So as court decisions are made over the hundreds of years, we have thousands and thousands of court decisions that we can use to help us decide how to do things, whether or not something's legal. Precedents, we call that. And I'll show you more what I mean in just a minute. But first I want you to know this term right here, so I have it highlighted, common law. I want you to know what I mean by that phrase, common law. So the term common law has a couple of different meanings, which are closely related to each other. So the first way that we use the phrase common law refers to the law that carried over from England to the colonies before the United States ever existed. English common law. This was the law that was applied in the English realm throughout the world at the time, the law that applied to the common public. And so basically that was the law that was applied in the colonies before the United States ever existed. So now let's fast forward, Revolutionary War, United States, the Constitution is now signed, we are now a sovereign country. So now what happens? Well, if you go to court, let's say we're 1795, right? Right after the Constitution was fully ratified. We didn't have a lot of United States law because Congress hasn't passed a lot of law at that point. We didn't have administrative agencies. We didn't have computers and all that. We had very little United States law. And so essentially what would happen then is if you're in court, maybe I'm suing you, you're my neighbor, right? And you took my cow, my milk cow, Bessie, my milk cow. So you can make butter. We're talking 1795. And you never gave her back to me. So I sue you in court because I want the judge to order you to return my cow. Well, when I go to court, I have to base my lawsuit on law. I can't just make it up. So U.S. law is basically the US Constitution at that time. There wasn't really any other law in the US. So when I go to court, I can't say, okay, judge, under the cow article, there's nothing in the US Constitution about cows or bovines, nothing. So what would the judge do? The judge would look back at Old English law and say, okay, well, we're going to apply English law here because we don't have any United States law. And so basically they would apply English common law in the United States. And that has developed over time. And so now, courts still do this, not very often. Now we have plenty of our own law. But every once in a while, you'll have a situation where the court will look back and say, okay, what was English common law on this particular issue? So that's one meaning. The second meaning, which I think is more relevant today, is what we call judge-made law. That is the law that's created over time with all these hundreds and hundreds and hundreds of cases that we have, that we can research, okay? So on the test, common law refers to English law and judge-made law. Judge-made law and English law. They're kind of the same thing, right? So a judge would apply English law, see what I'm saying? So let me show you how it works in the real world, all right? Real world. Page 13. Real world time. I'm going to give you guys a little quiz here. Not really. Okay, this is ORS 163.175. Came out of this book I'm holding right here. Literally, I photocopied it, put it in this book. ORS 163.175. Okay, so first of all, remember categories of law. First two categories are what? The two biggest categories. All laws are divided into two types. What kind? Civil and criminal. Very good. How do we tell the difference? Reminder from last week? Jail time. Okay. So this law, is this a civil law or a criminal law? Criminal. How do you know? You're correct, it is criminal. But how do you know that? It's assault, but actually assault can also be civil, but that, you're on the right track. Second degree, implying what? How do you know it's a crime? Criminal law, by what? Jail time, okay? Now the other way you would know that this is a criminal law is it says right there, crime. I had a judge once, I was in court, I was making an argument to the judge, and I was not doing very well. I had a really bad case. I knew I was going to probably lose. And the judge looked at me and said, Hasbrook, have you read the statute? Because you're arguing something that's totally opposite the statute. I'm like, I know, I'm arguing the facts, not the law. I'll explain why that's relevant later. Okay, so now we know it's criminal. Federal or state law? State. How do you know? Oop. ORS, right? That's why I wrote that up. Okay. Harder question. Procedural law or substantive law? You guys stay on page 13. Just want to go back to page 3 and show you the words again. Page 3. Procedural or substantive? Procedural, what steps you go through. Substantive law is a definition, a monetary amount, an age, an interest rate, something like that. Procedural law, what steps you go through in court. Substantive law, what are you trying to prove? What is the definition of something? Okay. So, is page 13, is this what steps we got to go through in court, or is this a definition of this crime? This is a substantive law. It is the definition of this crime. Now, this is what we would have to prove in court beyond a reasonable doubt to find somebody guilty of this crime. Procedural law would be like what steps you got to go through in court, through a jury trial, evidence code, all that kind of stuff, right? So, let's not get hung up on that. Remember what we're talking about? We're talking about interpreting. Judge-made law. That's what we're on. So what does that have to do with this? All right. Real world. This is a very common crime. This is also a crime that will put you in the penitentiary under Measure 11. First offense, for 70 months. That's 7 times 10, right? It's a long time. No prior record. Really common crime. I used to prosecute this one all the time when I was a DA in Multnomah County. So, the most common way, there are 3 different ways that you can commit this crime. Letter A. One way is if you intentionally or knowingly cause serious physical injury to another. Serious physical injury on purpose, right? So if I walk up to you, I pick my thumb, I gouge it into your eyeball, I pull your eyeball out and throw it in there. Serious physical injury, I did it on purpose. That's going to be this letter A. I had that case once, that's why I used it in an example, that exact case. Letter B, more common. The alternative way you can commit this crime is if you intentionally or knowingly cause physical injury by means of a deadly or dangerous weapon. Not serious physical injury, but just physical. That's a bruise, a cut, swelling, something that's not permanent. Serious physical injury is permanent, okay? Permanent impairment. So here's the difference. Worse injury but no weapon, lower level injury but was caused with a weapon. That's the difference between the two. And then letter C, we're not going to worry about. All right, so remember what we're talking about, interpreting judge-made law. So now, we got to look at this. Deadly or dangerous weapon. What does that mean? This is what a judge does in the real world. All right, so what's a deadly weapon? You got to interpret what that word means. What does it mean?
Something that's designed to cause death or injury.
Exactly, very good. Something that has as its design, its purpose. Not some other purpose. The purpose is to cause death or an injury as its primary purpose. So classic example is like my wife's lasagna, right? I mean, no, a gun. Yeah, if you've ever had my wife's lasagna, it is awesome. Homemade noodles, they're all rolled out with a roller. She makes homemade sauce for, like, cooks it for 12 hours with 3 different kinds of meat. Homemade bechamel, white sauce. Oh, I'm getting hungry just thinking about it. And you eat so much of it, it kills you. Literally. Don't tell her. Ooh, my video. Hi, Michelle. All right. So, deadly. No, a gun, right? A landmine, a lightsaber.
Sword.
Some kinds of knives, yeah. A sword. Some, like a pocket knife or something, has other purposes, but the courts struggle over that all the time. All right, that's not what we're concerned about. We're more concerned about this one. A dangerous weapon. Now remember what we're talking about, judge-made law, right? Dangerous weapon, what is that?
Could be a pen.
You're right, it could be. So here's what I'm leading up to. We have a court case here in Oregon from years ago where a guy had cowboy boots on and was kicking another guy with the cowboy boots and causing injury to the victim with the cowboy boot. Now, it wasn't major injury, it was like bruised and cut, so not serious. But the idea then was the guy was charged with this crime for causing physical injury intentionally by using a cowboy boot. A dangerous weapon, to wit, a cowboy boot. And so that went to trial. The guy was convicted. He then appealed his conviction, and it went up on appeal. It got published in a book that looks like this. And the court said, the issue was, okay, is a cowboy boot a weapon? No, it's footwear. It's not a weapon. And the court said in the decision, any item, physical item, potentially can be a weapon if that item is used intentionally by the person, or knowingly, which means you know what's going to happen, to cause an injury more so than the naked body part would cause. That's basically the decision. So that opened this door for a pen, a pencil, a car key, a sidewalk, pounding somebody's head on the sidewalk, an automobile, clearly if I run you over on purpose, could be a weapon. So basically the idea is anything potentially, physical item could be a weapon in that definition. And so now that's where judges have to interpret. Yeah.
Okay, so we're talking about judgment law.
Mm-hmm.
And you said that anything more than what the physical body is capable of?
So
Provided
basically,
you're not using the sidewalk. or-
basically what the court was saying is, okay, the concept of a weapon is an item, that you're trying to cause an injury more than the naked body part would cause. So my naked foot, if I'm kicking you with it, yeah, I'm gonna cause you some injury, but when I put a boot on it, now it's gonna cause a lot more injury than just my naked foot. And so the concept of a weapon is one that, I've gotta be doing that on purpose, intentionally using that boot. It's not like, okay, I'm trying to get the boot off my foot and it flies off in the air and hits you in the head. That's not intentional. I didn't mean to even hit you. It's I'm kicking you with it, and I know I'm using that boot as a weapon. So you gotta couple this word with weapon and with injury. I have to cause that injury with that weapon. Now, back to the concept, judge-made law, right? So, here's what's going on. When a judge makes a decision like the cowboy boot, it's kind of like the judge is taking a pen or a pencil and writing in there, including a cowboy boot, including a car key, including a sidewalk, including a pen, including a book, including an Apple iPhone, whatever. Right? And so over time, we have a whole bunch of court cases where we can say, okay, cowboy boot, and it's basically writing law. Now, let me ask you this question. Is the judge making law when they say cowboy boot? Are they legislating? Or are they interpreting? See the difference? No, the legislature wrote this law. The judge is just applying that word to a particular situation. A cowboy boot, a car key, a lasagna, whatever, right? That's what happens in the real world. And then that gets published in a book like this, and that's how we research it. So when I say judge-made law, that's what I'm talking about, all these different court cases over time. Now, is it legislating? Not really. But it has essentially the same effect as legislating. And literally, when the U.S. Supreme Court makes a decision about the United States Constitution, it's kind of like rewriting the Constitution itself, in a way, because it has that same level of authority. All right, so common law means what? English law and judge-made law. Very good. All right, so I had a case once. I got to tell you a story. I got a little bit of time. This is true. This is when I was a DA in Portland. So 2 guys going to a bar. Sounds like a joke. But seriously, 2 guys are in a bar, and so they're sitting at the bar in their bar stools, and they knew each other from high school, but they weren't really friends. They hadn't seen each other for a long time. And so the one guy was he would fish. He was a tournament bass fisherman. So up on the Columbia River, they have bass tournaments all the time. You go out on your boat, you catch smallmouth bass, maybe a largemouth here and there. But long story short, he won a tournament, and one of the prize, he won some money, and then he won a bit with those big old belt buckles. It's like a rodeo-style belt buckle, like the Geico commercial, And so it was about that big. I mean, about the size of this, not quite as big as this book, but pretty close. So they're at the bar, and they're talking about this bass tournament, and the guy takes the belt buckle off, and, well, it's actually probably about the size of this book. And so he's showing the guy, for whatever reason, they get into an argument. And they've both been drinking a lot of beer. And so the guy with the belt buckle whacks the other guy in the face with it. He has the leather part, the belt, and whacks the guy in the face with the belt buckle. A big old imprint on the guy's face. The guy fell down, had a bruising and swelling and all that. All right, so the police show up, of course. Guy gets arrested, and they charge him with this. What do you think? If a cowboy boot can be a weapon, what about a big old metal belt buckle? Oh yeah, big time, right? Physical injury, weapon, done intentionally, that's assault too, right? Okay, so guy got arrested, came to my desk. My job at the time was to do what's called intake, was to decide what charges we're going to file. So I'd read the police reports, the police officers would make an initial decision, and then it was up to me as the DA to make the final decision, and then you take it to grand jury, and then they will either issue an indictment or not. So I took the grand jury, told the grand jury about the cowboy boot case and all that, and so they indicted the guy for assault to letter B and using a cowboy boot, the belt buckle. So we went to trial. At trial, the guy that was accused waived his right to a jury. You have a right to a jury trial. It was a felony. That's 12 people in Oregon. But he decided he did not want a jury. He wanted the judge to decide the case. We call it a court trial. And so the judge is going to make a final decision. That's the basic idea, right? And there are reasons for that. Primarily, a judge will focus more on the law than the injury. That's the bigger reason. All right, so we went to trial. The guy was hurt, testified exactly what I said. The guy hit me in the face. We showed pictures of the injury and all that. So, you know, pretty much looks like he's guilty. So the accused decided he wanted to testify. Now, he didn't have to testify. You have a right to remain silent. You don't have to testify in court. Most of the time, people that are accused of a crime do not testify, because you might admit something and get convicted. But this guy wanted to testify. So he testified that, yeah, we've been drinking, and you know, I was at that point fairly inebriated. I was fairly drunk. And I was showing this guy who I knew from high school this belt, talking about the bass fishing tournament. And I was so drunk that I fell off the bar stool, lost my balance, and started falling down. And as I fell down, the belt whipped up and hit him in the face. If that's true, is he guilty?
No, that's reckless.
It might be reckless, exactly. Or it might not even be reckless. It might just be, the guy was drunk and fell down, right? And if that's true, then what? Is he guilty or not? Not really even guilty, yeah. Not,
Of that crime, I guess.
so what?
Not of that crime, I guess.
No, is that correct? Okay, yeah. Sorry, my hearing is,
Yeah,
I used to do a lot of scuba diving, and it's just, my hearing is horrible now. All right, so, assuming that's true, no, he's not guilty. So now, after that guy testified, I called the security guard who saw the whole thing happen. And he came and testified, he said, well, I saw before the other guy got hit, I saw the guy raise his arm before the strike. Is that different? What does raising your arm imply?
Knowingly and intentionally.
All right, you're going to throw a ball, or you're going to hit somebody, you got to cock your arm back. So that implies he did it on purpose, not falling. What was his rebuttal to that, do you suppose?
Well, I'll put your arm out to start to fall.
Right. You go to fall, what do? Right? Do you know what the answer is? Are you sure or not sure? If you're not sure, we have a phrase for that. What do we call it? Proof beyond a reasonable doubt. So you guys are all sitting there going, I don't know. I don't know. I don't know, which means reasonable doubt, which means what? Do you know? Not guilty. You have to prove beyond a reasonable doubt. And that's what happened in that case. The judge basically said, I don't know. I don't know who to believe, and that's reasonable doubt, and therefore found him not guilty of that, but did find him guilty of a reckless assault 4, which is a misdemeanor. Okay. Right? I just have to change the battery, so.